All right, great. So let's get started. Thank you everyone for attending this evening. My name is Nicole Rizzo. I'm an educator and volunteer for the Connecticut Public School Advocates. Connecticut Public School Advocates is a newly formed organization. We are advocating for equitable and safe education for students across Connecticut. We believe strongly in the value of high quality education as a right for all children, regardless of race, ethnicity, or gender. Over the past months, Connecticut Public School Advocates has worked diligently to advocate for the safety of our communities through the lens of school reopenings. We know that education is a cornerstone of our society, and we understand that opening schools during a pandemic impacts entire communities. That means teachers, administration, paraprofessionals, custodians, bus drivers, food service, students, families, first responders, and nearly every individual who works outside of their home. In the past week, since schools have reopened, we have seen the single largest COVID-19 infection spike in 4 months in Connecticut, reminding us that it is imperative that all unionized workers, not just leaders, join in advocating for safety in the face of a pandemic. Governor Lamont's metrics for remote learning in schools require that we reach the same community transmission levels that we experienced at the height of the pandemic in April. That's what it's going to take to close schools. Furthermore, the state has relied on the guidance of the Harvard Global Health Institute in order to determine its leading indicator thresholds. However, the state's guidance deviates from Harvard scientific recommendations for that category, which clearly states that in the absence of conditions for pandemic resilient teaching and learning spaces, schools continue with remote learning. Pandemic resilient learning spaces are defined as those with enhanced air ventilation, upgraded filtration, sanitation resources, hygiene practices, pandemic resilient bathrooms, physical and group distancing. The vast majority of our public school spaces are not equipped with these requirements. And despite our state's concerning COVID-19 metrics, many districts are preparing to fully reopen school buildings come November. On behalf of Connecticut Public School Advocates, we thank DeMarcus Fennell from Representative Johanna Hayes' office for attending this evening, and we wish Representative Hayes a speedy recovery. We also extend our thanks to the 7 senators who have advocated for thinking creatively about opening schools this fall, requesting that contact tracing and outbreak response be prepared prior to schools fully reopening again. Unfortunately, this request was ignored by our state leadership. Individual districts are left to conduct contact tracing on their own. Right now, we are living in a historical moment. It is one that presents a great challenge for humanity. However, with great challenge can come great opportunity and growth. It is with excitement that I hope to join you in transforming the future of our public education and our greater society. To do this, we must care for ourselves and care for each other. We must invest in each other. We must unite, and we must advocate for collective change. Thank you for taking the first step in doing so by being here this evening. I've just shared a lot of information about public education, but our guest tonight is going to be sharing helpful information for all unionized workers to organize and impact change in our communities. Without further ado, I'd like to welcome McGinnis, Executive Director of the Workers' Action Project. Mac has been involved in the labor movement for the better part of the last 20 years. Formerly, he was with the United Electrical, Radio, and Machine Workers, where he began as a mechanical tech and was elected as chief steward of his shop. Later, he was hired as a union organizer and rose through the ranks to serve as an international representative for the union handling strikes, National Labor Relations Board cases, grievance arbitrations, and contract negotiations. Early this year, he helped to organize and became the executive director of the Workers' Action Project. Workers' Action is a worker center serving New England in the New York City area. Workers' Action fights to build union power through educational and organizing assistance to unions and their members, as well as uniting the labor movement with their communities to fight for a world based on worker and community power. So thank you so much, Mac, for being here this evening. I also want to introduce Marissa, Rose, and Taylor, who are here as well on behalf of Public School Advocates. But again, thank you, Mac, for being here, and I will let you begin.
All right. So it feels good to be union tonight, right? So I'll just thank you for the kind introduction, Nicole. It does. It feels good to be union tonight. I'm really heartened to see, so many participants on this webinar who are, interested in learning, more about and learning about how to enforce, their safety rights on the job, right? That's going to be the content in context of everything we talk about tonight. I'm going to try to keep things, I know how Zoom meetings are. And I'd like to leave a lot of space for, questions and answers and things like that. So I've got a lot of slides and a lot of information to go through. And we're going to, leave a lot of space for, everyone to ask questions, which you can do through the chat box. Nicole is going to pick out, sometimes, you get like duplicate questions and things like that. Nicole's going to pick out those questions after I go through each slide and bring them up to me. After we get through my presentation here, we're going to have a more in-depth question and answer period so that, people don't feel like, they have to stick on, a call for like 2 hours. So there's a lot to go through, but I'm going to try to keep it as concise as possible. So, all right. What we're talking about tonight is union workplace safety and our responsibilities by virtue of having collective bargaining rights to fight for safety in our community, right? Now, fighting for worker protections during the pandemic is of key importance to the labor movement because, when you're dealing with a problem like this, it extends beyond our workplaces, and we want to prevent our workplaces. I mean, and I know there's a lot of teachers on tonight, and this is of particular immediate importance, right? We want to prevent our workplaces from becoming vectors for the transmission of the disease, because this affects not only us, not only the students in the schools, but also their families and everyone in the communities that we live, right? And I'll note, just Connecticut is one of the states with the highest wealth disparity, right? So this raises particular questions of race and class oppression, right? That as union members, as union leaders, and as workers' rights advocates, we have a unique opportunity to organize around these questions and to fight for real justice in our workplaces and in our communities here. All right. So just to introduce, my organization a little more, the Workers Action Project, we're a worker center. We're a 501c3 not-for-profit workers' rights organization. And our purpose is to try to bridge the power of labor and the power of our communities to fight for a better world, right? I'll talk a little bit more about this at the end of the presentation, but what we primarily do is cross-union organizing and coordination work, and union community coordination work. And, fighting for, everything from different policy measures to organizing strike support, things like that. We also, a big thing that we do is we run a workers' rights hotline. I'll talk about that at the end. And we provide a lot of educational workshops for workers and local labor unions, right? You can find out more about us at workersactionproject.org. And I encourage you to check out our website and, see what we can do for, like your communities and your local labor unions. All right, you ready? Good. So I'm not going to belabor this too much because I'm sure I know there's a lot of teachers here and you've probably heard a lot of this ad nauseum at this point. But, you know, I mean, the basic points about the pandemic right now is this is a serious matter. Our political leadership has really not I'm sure is evident to everyone. Our political leadership has really not taken any leadership role in dealing with this. And that's been reflected in our workplaces as well. Everything from factories to schools to, you know, public transit, you know, operations. There has not been a science-based mitigation strategy to make our workplaces safer. Now, that is outside of collective bargaining, where unions have bargained proper safety measures and been able to hold management accountable to those things. But I mean, all of you know, you got to wear masks, stay 6 feet apart. These things are non-negotiable, right? And I know in Connecticut, a number of public sector unions, in fact, signed onto a letter last May that they put forward to the state that talked about how, you know, there's a number of safety, you know, issues that are in fact not negotiable issues. These are things that should be held hard and fast and not subject to any modicum of management interference. Now, where, you know, there's the most risk is, you know, indoor workplaces with a lot of people. Schools, I mean, I think are sort of a natural place where this can happen. And it spreads, you know, beyond schools throughout sectors, closed factories, in particular, maintenance workers, transit workers, all of these people have been at risk and continue to be. Now, let me put it like this. Unions and our members, we collectively have specific responsibilities and rights, in fact, like I was talking about earlier, to fight for, you know, real mitigation strategies through collective bargaining that we can use to, you know, win greater safety rights, which will, you know, like be reflected into our communities and protect our neighbors and family members. And I'll note this. When I talk about, I talk about the union a lot in this presentation. When I talk about the union, I'm not talking about a third-party organization, right? The union is you, right? The union is the workers who make up the organization, right? Like, unions are not like insurance companies or like prepaid legal services companies. Unions are the workers who make them up. And I would encourage all of you, if you're not already, to get involved in your local unions, right? To, you know, run for office, to become shop stewards or delegates or whatever you have in your shops. And, you know, be involved in the day-to-day, you know, operations of what are your class self-defense organizations, right? That's what unions are, right? They are working class self-defense organizations. All of the protections that we have as workers, you know, the 8-hour day, every holiday we have, you know, things like health insurance, pensions, 401ks, sick time, all of these things have been waged through hard-fought struggles, you know, won by workers, you know, out on the picket line and in their workplaces, right? You know, we've got a responsibility not only to, you know, ourselves, but to our neighbors and family members to, you know, like take up issues that, you know, are going to forward the cause and forward progress of the working class. And as we'll talk about, union agreements are, you know, one of the most powerful ways that we can do this, right? All right, Nicole, any questions so far?
Not so far.
No? All right, good. All right. So, like I was just talking about, the most powerful right that we as union members have is called collective bargaining, right? That's our right under law to mutually defend each other and to bargain collectively with our employers. Now, all of your contracts have what's called a union recognition clause. This provides you with specific protections against something that's called unilateral changes in employment, right? Unilateral changes in working conditions. Now, what that means is management, for whatever reason, is prohibited by virtue of your union contract from changing the conditions that you work under and the terms of your employment. This is particularly important right now because even though there's a pandemic, right, and even though there are necessary changes that have had to be made to workplaces, like for example in schools, there's like online programs, there's the hybrid program. Certain schools are operating at full capacity, but like you need to maintain social distancing. These are all changes to the terms and conditions of your employment. This makes them mandatory subjects of bargaining that your employer needs to negotiate with your union, right? And again, I want to note, when I talk about the union, I'm talking about all of you, not just the elected leadership, right? So in addition to your protection against unilateral changes, your union contracts usually codify specific safety and working conditions protections. There's normally some clause concerning safety and working conditions. And beyond that, there's also a number of past practices or other agreements that there may be with management that provide you more specific protections outside of just your protection against unilateral changes. The way you enforce the contract is through your grievance procedure, right? So for example, if management if management said, all right, well, I'll just use an example. Say you're in a 20-foot by 20-foot classroom and you can only fit 6 kids in there because of the social distancing requirements that like the CDC and OSHA has put forward, right? You could file a grievance if management said, well, you need to jam 20 kids into that classroom, right? So using the grievance, understanding your contract's grievance procedure and being able to use it is of key importance. Also, using external law. Now, external law is any workplace protections that are outside of your contract. For example, food workers can call their local health department. We'll talk more about OSHA and in Connecticut, con OSHA in a future slide. But there's also things like the Family Medical Leave Act, the Americans with Disability Act. There's discrimination protections, that, exist through like different state level human rights commissions, the EEOC, and state attorneys general. I will note though, whenever you try to operate external law, you also want to deal with your shop steward and have grievances filed concurrently, because the law is often insufficient to quickly remedy workplace problems. Oftentimes your union grievance procedure is going to be the much more efficient way of getting that done, right? But you should operate the two concurrently. Now, since the pandemic, earlier this year, they did pass this thing called the Families First Coronavirus Response Act, which provided some extra FMLA time for people who have been actively infected with the virus, right? It was a gravely insufficient law. And I mean, again, this is why I really want to emphasize, you should become shop stewards or talk to your shop stewards and use your contract and use your grievance procedure. Because uh, the new FMLA extension, while it does grant you extra time if you become infected, it does not protect workers who are vulnerable to the virus. In fact, it encapsulated those workers into a separate category and called it generalized fear, right, of contracting the virus. And it specifically excluded them from using FMLA time, right? That's pretty cynical. So using your union contract is of key importance here. Understanding your contract and understanding external law is good. And, you should talk to your union. At the end of this presentation, you'll also have the workers' action, phone number. Like, we're always happy to help people answer, legal questions as well. All right, Nicole, any questions so far?
Yes. Okay.
Hit me.
So at the end of the summer, the largest unions in Connecticut set forth non-negotiable safety principles,
Yes.
like masks required of all students regardless of their grade level. Students and staff must maintain a distance of 6 feet at all times. It's a list of 13 principles. So if those principles are not being followed, how can educators take action if their union leadership is not pushing these issues?
All right. So that's a really big question. So that letter that was drafted was a political position letter that a number of unions signed on to, right? Now, hopefully a number of those principles ended up being covered in workplace-specific memorandums of agreement, which are interim contractual agreements that exist alongside your union contract, that protects your working conditions and your health and safety when there are changes to them, right? So like during like the pandemic, there's specific safety concerns, and there needs to be a specific agreement to address those, like specific concerns, right? Those types of agreements may include everything from, like safety rules, like mask requirements and social distancing requirements, to like affirmative things like hazard pay, perhaps, or extra sick time, or other extra contractual benefits that rise as a consequence of the change in your working conditions. Now, I know a lot of unions have bargained these interim agreements, and I'm aware of a few work sites where there are not these types of interim agreements, right? We'll talk about this a little more later, but I would push your union leadership to bargain for these types of protective agreements if there's not one that exists at your workplace. So basically that's what I would have to say there, right? I mean, if you don't have a special protective agreement during the pandemic, you should. If you need a copy of it, your union should be able to provide you with a copy of it, if there is one. And if there's not, you should push them to negotiate for one.
Okay, so you're saying that those principles should be addressed in the memorandum of understanding, the MOU, and if they're not, then union rank and file members should advocate within their local union leaders.
Yes, absolutely.
Okay, thank you.
Anything else? All right, let's keep going. So, there are some powerful rights that you can immediately exercise that are both encapsulated in your contracts and codified into law. Now, back in 1970, the Occupational Safety and Health Act was passed. It requires that employers abide by these things called OSHA standards. And there's hundreds of OSHA standards, depending on what industry you're in. You know, if you work in a factory, there's like OSHA standards that talk about noise. There's OSHA standards that talk about metal shavings. You know, if you're in, you know, if you work in a university, there's OSHA standards that talk about, you know, like access to restrooms, you know, things like that, right? I mean, there's OSHA standards that cover like hundreds of very specific aspects of every workplace. And there's also a general duty clause as part of the act that says employers have the affirmative responsibility to provide workers with a generally safe workplace that's, you know, not going to put them at risk of life and limb, right? So that act is enforced through, for private sector workers, the Occupational Health and Safety Administration. Here in Connecticut, for public sector workers, it's through the OSHA. It's the state level OSHAs basically are just the state level operating organizations of the federal OSHA, right? I mean, there's no real appreciable difference. All of the same standards exist and are adopted. Now, all workers have the right to file OSHA complaints, right? So in Connecticut, you would file that complaint with OSHA, and you go to that website, you know, to pull up the forms to do so. Now, when you file a complaint with OSHA, you are legally protected from being, now, and I want to reiterate this, you are legally protected through the operation of law from retaliation and discrimination, right? Should your employer retaliate or discriminate against you, you know, by virtue of you filing a complaint, or I would also note, you know, should you file a concurrent grievance, you know, surrounding safety issues, as you should, if they retaliate against you on that basis as well, you are also legally protected, right? This probably bears some mention right now. Workers are, in fact, no more protected than when they are engaged in collective actions to defend themselves and their coworkers, right? And when they're filing grievances or complaints under external law, right? So you can file these complaints, and you know, OSHA doesn't call up your boss and say, you know, Frank or Mary filed this complaint, right? It's done ostensibly anonymously. And OSHA will come in and do a safety inspection and investigate the complaint you made, right? And in Connecticut, not all states are like this. We're actually pretty lucky here. OSHA is pretty good about being timely about investigating these, you know, these types of workplace safety complaints. So it's a tool that you very likely may be able to use in your workplaces. Now, this works in tandem. I'm going to hold questions right here because I've got another slide, which I suspect this is going to generate some questions. So this works in tandem with the worker's right to refuse unsafe work, right? Now, again, this is a matter of the Occupational Safety and Health Act of 1970, right? I mean, again, your union contract probably provides you with additional protections, but it is very important that you understand your rights, right? Now, with matters of external law, you know, with OSHA, there's always caveats too, right? So, under certain circumstances, workers have the unequivocal right to refuse to perform work that puts them at imminent risk of death or injury under very certain circumstances, right? One, you must notify your employer that there is a danger and ask the employer to eliminate that danger. And if they have failed to do so, you then, in good faith, which means, you know, like you have to genuinely believe there's an imminent danger, right? You refuse that work. 3, we could talk about this further at the end maybe, but a reasonable person would agree that there is a risk of imminent danger or death, right? Like, and if this thing is in fact imminent, right? And there's not time for OSHA to come in and conduct an inspection and remediate and compel management to remediate the problem. You then could take, you know, the following steps, right? Tell the employer to fix it, and then tell the employer prior to refusing work that you're not going to do work unless it's fixed. And then you've got to stay at the work site unless you're ordered to leave. Now that's a lot. I'm going to give you an example, like a very simple example to show you like kind of how this operates in the real world. Very simple example. Say you work in a factory and the boss wants you to work at a machine that catches on fire routinely. You tell the employer, this machine catches on fire all the time. This is unsafe. Fix it. If your boss says, no, I'm not going to fix it, then you can say, well, I'm not going to work on that machine. And then you stand around. Then you say, well, give me some other work, right? And if the boss says no, then you stand around until they tell you to leave. So in real life, it simpler than all of the qualifications that, you know, the slide puts forward here. It actually works much more simply than it reads. Now, I will also note the language that I put up on this slide. So when this is done, anyone who wants to provide their email addresses can get a PDF copy of all of these things, plus a few extra handouts that Workers Action Project publishes that have to do with workplace safety and OSHA. But I'll note the language that is on this slide comes directly from both the OSHA website, and I'll note that this should not come as a surprise to, you know, any union leaders, because it's directly referenced from the AFL-CIO website. They actually have a very good website called knowwhentosayno.org that provides some additional information about work refusal as well. So I would encourage all of you to check that out as well. All right, Nicole, any questions so far?
Actually, I'm going to share the questions with you right now. So First question is, has the Connecticut OSHA specifically addressed COVID in their standards?
No, so there's not COVID standards. What my understanding is what the CON-OSH has done is relied on CDC guidelines as being the primary protective mechanisms. You can still file complaints and they will address those, but there's not like numbered adopted standards to my knowledge. But you can file complaints using the CDC guidelines in the same way, from what I understand, for public sector workers.
Okay, and how would you recommend handling the discrepancies with the with contact tracing between districts, since we're just following guidelines?
So contact tracing is, contact tracing is an interesting question. So I'll say I'm not a doctor, so you can take what I say with a grain of salt. The only thing I can really speak to is the bargaining implications of it, right? Whatever the particular mechanisms that they're using to do contact tracing, in each district. I would say for teachers, each of the teachers union should probably engage and retain a medical expert to give them a written opinion about what contact tracing should entail. And they should use that as a guidance basis for bargaining, a side letter or an MOU that covers the particularities of contact tracing if they're able to do so. I mean, it's contact tracing is one of those kind of like, we could probably talk about this more at the end, because the more I think about it, the more complicated I think legally it becomes, because there's a nexus between your working conditions, health information, which is likely going to be HIPAA protected, and whatever modifications to your workplaces would need to be made as a result of, like the contact tracing chain that results whenever cases take place. You know what I mean? This would be a really interesting thing that, like we could probably work up like a legal opinion, and like write a brief on it.
How
but that's,
about that?
yeah. Hit me.
I was going to say, how about that they are having teachers and other union members do that tracing? Is that appropriate for them to ask?
Let me ask, so this may be like an individual grievance issue. So I would say that would depend on what exists in any MOU that you may follow under, right? And then, so for something like that, it would have to do with your MOU. If there's any extra work provisions in your collective bargaining agreements, and if, I think probably more presciently, if you guys are, first of all, trained to do this through PD or, any like specific trainings or anything like that, and whether or not it's possible that you would be able to abide by the HIPAA protection requirements. Now, if I was a teacher's union rep, that would probably be a big concern that I would have. If they're making teachers engage in collection of potentially protected medical information, right, without being trained about the legal implications of possessing and transmitting that information, that may put teachers at a level of legal exposure that I would, that I as a teacher may not be comfortable with. You know what I mean?
That's Matt, can I add on to that?
Yeah.
Because that's a reasonable refusal. I'm going to make reference to the existing and rather dated MOU for our town of Wyndham. No adverse action will be taken against any bargaining unit member who elects not to report to school building during school closure. Also, if things have been met according to the CDC recommendations, they can perform their work responsibilities in the building while maintaining social distance, etc. But we do not have in here any element that says an extension of a requirement or an expectation of that nature. And if it's not in your MOU, you don't do it.
Yeah, no, so, yeah, so there's, those are, yeah, I agree, Rose.
Okay.
I couldn't say it better. The only thing I would add is that, So talking about, so if it's not included in the MOU, if management did threaten to discipline you, right? They should first, you should first, stick up for yourself, right? Talk to your union steward. And if they try to refer to the absence of an MOU as being cause to make you do that extra work, right? I would argue that, in fact, this is something we could probably talk about more later because it's actually somewhat of a complicated legal argument. But because of the components of the just cause protections that all of you have as a function of, being union members and having a collective bargaining agreement, there's in all of your contracts, there's an article probably called Discipline and Discharge that says no worker shall be disciplined or terminated except for just cause. Now, there are 7 components to just cause, and there's a number of those things which we call tests, which actually would provide protective measures for you there. All right. Anything else about refusal of work?
Yep, we actually do have one more. If somebody refuses to work due to a reasonable risk and they're told to leave, what happens to their paychecks?
That's a good question. That may, if your contract describes compulsory use of personal or sick time, you would probably default to your paid time bank being docked for that, right? If that happened, I would certainly file a grievance over it. My position always had been when, members that I represented had to refuse work and management refused to reassign them or offer them alternate work, we would say, yo, that's on your time, right? That's not, our members should not be compelled to have to use any modicum of paid time because of your failure to protect their working conditions and provide them an alternate assignment when what you gave them was, patently unsafe, right? You can't put us at risk of life and limb and then expect us to pay for wanting to keep our figures, you know what I mean? But I think that's probably what would happen in that situation. If there are compulsorily used paid time banks, they would probably dock those unless they told you otherwise. And if they did, you should file a grievance over it.
All right, thank you. I think that's it for now. You can move forward.
All right. So in talking about union safety, just from, like a collective bargaining standpoint, I really want to reiterate, union safety is one of the fundamental basic protections that union workplaces provide. Like, this is not like, these are very basic ideas. Like, this is not like, these are not radical proposals, right? Union safety, again, are very basic protections that you get by virtue of being a union worker, right? That in fact, the National Labor Relations Board decided back in a landmark case in the 60s that health and safety concerns are a mandatory subject of bargaining, right? Now, I know there's a lot of state workers here. So teachers, you fall under the Teacher Negotiation Act in Connecticut. Municipal workers fall under MERA, and state workers fall under SARA, right? Each of these state labor acts that you follow under mirror the Labor Relations Act in most important respects, right? I mean, in some, there's differences where it talks about your right to strike and, different things like that. And what happens, like, should you go to, impasse over your contract, like they include like mediation and arbitration procedures. But for most like substantive day-to-day, like grievance handling, safety purpose, things like that, what are and are not, mandatory subjects of bargaining, they directly mirror the National Labor Relations Act. Again, I can't reiterate it enough. Union safety is a basic and protected right that you have, right? Now, I would extend it even further than that. I would say that you guys as union members should seek to take an active role in governing your workplace safety, right? Now, I'll just tell you a little story. So the first position, I can't remember how long ago this was. I was a teenager probably at the time. The first union position I had was as chairperson of my union locals health and safety committee. Now, the boss was doing a terrible job of maintaining safe working conditions at the place. We filed a ton of grievances all the time over, unsafe working conditions. I mean, like just the floors were wet, fire extinguishers didn't work, like the exit signs were like hanging off the ceiling. It was just awful. So we filed a ton of grievances, and we ended up actually settling all of those by negotiating this thing that we called the Union Safety Checkoff. Now, the union, in fact, took control away from management over workplace safety. We conducted a monthly safety inspection on the clock, mind you, which took, the better part of a day. It was a large facility. We conducted our own safety inspection and had a separate grievance procedure that we negotiated with management, which they agreed to. I mean, where we would say, all right, we found that, this fire extinguisher was expired or inoperable. You've got, a bunch of ladders piled up on the back, fire exit stairway, things like this. You've got a week to, fix, different timelines, but you have a certain period of time to fix these problems. Otherwise, it's going to go to a third step grievance, a step away from arbitration, right? Management fixed all of those concerns all the time, right? But what it entailed was workers actively taking charge, right, of the workplace, using their union power to compel management to provide us with a healthy working environment. Once we bargained that, and once we got management, on the program, it was actually very easy. And the union did a far better job than management ever did in maintaining those things, right? So, I mean, again, we could do a better job at managing our workplaces a lot of the time than our bosses can, it may not, so for you guys, it may not take the form of having a union safety checkoff. It may be, like establishing a safety committee, or, participate. A lot of union contracts have, already established committees, like labor management committees, where you can raise safety concerns that, we should have, like elected union members participate in, right, and advocate for their coworkers. And, as we talked about a couple of times before, during the pandemic, every workplace should have a side agreement, a memorandum of agreement, a memorandum of understanding, what have you, to cover the specific working conditions changes and safety concerns that have been brought about by this pandemic, right? If you don't have one, you should immediately talk to your coworkers and your union officers, and say, we need to negotiate one, right? Now, each contract provides for different timelines and things like that, so I can't speak to any individual circumstance. What I can talk about is organizing around it. All right, any questions before I continue?
There's been a discrepancy among teachers, and it's a big talking point. I don't know how much you'll be able to share about this, but maybe you could give some guidance. like I said, one of the big sticking points has been maintaining 6 feet, and it's one of the core safety principles as listed by the unions. And in response to that, administration and school leadership is saying, yes, we will provide 6 feet when feasible. So I don't know if you can share any insight on how unions might address approaching that.
I could give you my opinion.
That's great.
So if I was a shop steward and management could not provide that 6 feet, I would immediately file a grievance, right? And if so, I would encourage workers to use their grievance procedure under their contract and file grievances over those safety concerns. And if it's happening on a consistent basis and management is compelling you to work in non-socially distanced classrooms, you should call Con OSHA. You should talk to your union and call Con OSHA and stick up for yourselves. You're union members, you got the power, remember?
Thanks, Mac. And I also, someone had asked as well about the governor putting out an executive order and who has the final say about opening schools. And that one I can answer. So back in August, New Haven Public Schools, as a lot of you might know on this call, advocated successfully to start the year remotely. And the governor never legally mandated that schools needed to open in person. School leadership can and is still able to decide how they want to open their schools as long as a free and appropriate education is being provided to all students. So at the end of the day, that decision is left up to individual discretion at the district level.
I'm going to piggyback on that. That being said, however, some districts seem more vulnerable than others in regards to pushing back on that order. That's all.
Yeah, that's a tough question. So as that's a tough question. That would bear the intersection between executive orders and working conditions, like when you're a state worker. So where executive orders unilaterally change your working conditions, it does serve as a trigger by which the union has the right to, invoke their bargaining rights over that change in working conditions. Like I was talking about in the beginning, any unilateral change, right? Whether or not, it comes from the governor or from, the superintendent or from your direct supervisor, whatever. If it's an unbargained change, you as union members have the right to invoke collective bargaining prior to that change being enacted. Now, there are certain issues where when there's an executive order that becomes a matter of law, if your union contract has a severability clause, there's a very specific interaction between what an executive order may nullify in a collective bargaining agreement, right? But I mean, again, bargaining has to take place. Collective bargaining is key, right? That is the primary right that every union member has. Your union is your sole and exclusive bargaining agent, and no agency can, subvert the right of collective bargaining, right? Even if there is an executive order, your on-site management has to bargain with you about how it will be implemented. Now, if it's an executive order, you may not be able to prevent it from being implemented, right? But you certainly can negotiate over it, right? All right, we ready to keep going?
Let's go.
All right. So, safety in a union shop, you know, like when there are things that, so I think this is probably the real sort of like prescient question for everyone right now. When there are safety deficiencies, or there are like MOUs that need to be bargained, or, you know, there are problems we need to fix in our shop, these are in fact, you know, opportunities, very good opportunities that we can use for rank and file union member organizing to build our own power at the workplace, right? Now, a good way, you know, so it's a, and I'll say, the Connecticut Public School Advocates Group is awesome. And we've had a bunch of conversations, and, you know, like we've been talking about how to like intersect with members and like, you know, coordinate these webinars and things like that. And I was saying on a planning call we had a couple days ago, how much tougher it is now to do, you know, like worker organizing, because we have to do it over Zoom, you know? You know, conventionally, and, you know, like when you're doing union organizing, right? You know, you're passing leaflets or surveys from one person to another, and like getting, you know, person by person commitments, and, you know, things that are not like possible during a pandemic. So coming up with new and innovative ways of being able to interact with, organize, and mobilize your coworkers is an ongoing, you know, question that, you know, we, you know, like we're trying to navigate through as, you know, an entire labor movement right now. A good thing that we found, and I know like the two state teachers unions have sent out a number of surveys so far. So, you know, I wanted to talk briefly about surveying your own members. But really the question is, how do you identify your coworkers' issues, and how do you talk to your union? Not really talk to your union. How do you get in, use those as issues to get involved with your union? And how do you talk to management about these types of issues, right? So, you know, like doing a brief survey to collect your coworkers' issues, I have always thought is really important. Now, where the state teachers unions have already done these types of surveys, you know, maybe getting access to that data would provide useful, you know, like useful information, so you're not sort of like reinventing the wheel and like redoing efforts that have already taken place. If that's not possible, collecting your, you know, coworkers' issues, safety concerns, changes in your working conditions, like immediately, day by day, you know, hour by hour problems. Like you may not have a problem in your first period class. In your second period class, they may pack the kids into the room, and, you know, like you may be able to identify that that's, you know, an issue that you have the right to file a grievance or a safety complaint over, or maybe your shop steward can like talk to, you know, management about moving your class to a larger room in a certain circumstance or something, right? But you want to use these issues as an opportunity to mobilize your get to the core of the issues, and mobilize your coworkers towards some sort of collective action that not only will correct the safety problem, but will also build power among you and your coworkers, so that management doesn't create these problems next time, right? So, I mean, again, whatever you do, you should coordinate with your like union local leadership, and, you know, like share the data so that it can be used to guide them in, you know, like bargaining in MOU if you need them, or, you know, like provide them as the basis to, you know, like handle any grievances or arbitrations that may arise. Now, when I talk about collective action, the reason I always emphasize that you guys should get involved in, you know, collective actions, right? Meaning actions that are taken on behalf of the union or on behalf of a group of coworkers for their mutual benefit, is because you are never more protected under the law than when you are engaged in a collective activity for the mutual benefit of yourself and your coworkers, right? Now, that could be anything from engaging in your union grievance procedure to, organizing a button or a sticker campaign at your workplace, or doing a petition that you present to, your principal or superintendent or manager. Like social media speak outs, so long as, you're talking about, like the mutual benefit of your coworkers, right? Press events. I know public school advocates spearheaded a demonstration a little while back in Hartford that was really interesting and impressive. It was really cool. But it was, like a safe, socially distanced, very public demonstration, right? So, I like to emphasize the collective action piece, which I'll talk a little bit more about in a second. But any questions so far?
No, this is great, and I want to be mindful of everyone's time, and as much as we can communicate with people here how they can take action, that's
all right. So again, I'll send these out by PDF, so we don't have to talk about how to design a specific survey, but you always want to ask about changes in working conditions, and having people prioritize, safety concerns or bargaining concerns, right? Now, the question is once you have data, what do you do with it? You got to make a plan. So talk about those issues, list them in priority, coordinate with your union leadership, and craft a message that you use to organize and mobilize your coworkers, right? And then when you have that message, you always want to push forward with a collective action, right? Again, sticker campaigns, petitions, organizing, like social media speak outs, socially distanced demonstrations, things like that, right? Things that will put pressure on your boss to compel them, along with your grievance procedure, in order to get them to remedy these problems. And along the way, you are getting your coworkers involved in the union, and you're building your own power. So hopefully in the future, again, it will prevent management from creating the problems that you're having to have a battle over right now, right? You should think about organizing like this. When you're planning an event or, a petition or an action, you should have different levels for your coworkers to get involved at, right? Some people may be comfortable putting on a sticker. Some people may be comfortable signing up for an email list. Some people may be comfortable coming to a webinar, right? You should always, have some way, we call them tests. You should have some way of measuring what level of participation people will, get into before you take any actions also, right? So I mean, again, you always do this with the idea that you're building workers' power at your workplace. So, anything there? Good? All right.
Yeah, we can keep going. I will plug really
All right.
quickly. Wearing black on Fridays is a way for teachers to show solidarity. That's been going around on social media, and I will remind everyone of that at the end as well. But wear black on Fridays as a show of solidarity.
All right. So, I mean, basically, that's what I had to talk to all of you about tonight. I just wanted to, put a few more things, forward before I wrap up my part here. So, for you guys as individuals, for your union locals, the Workers Action Project provides a number of, like trainings like this. We do, shop stewards trainings. We do workers' legal rights trainings, grievance handling trainings, organizing trainings, like a workers' protection from unjust discipline, using past practice in your workshop, contract bargaining. I even do a training about how to do contract costing, right? If you want to learn how to, bargain a contract and figure out, how to make an Excel file to figure out, what everybody's going to make and what it's going to cost the employer. So I would encourage all of you to get in touch with us if your union locals or community organizations need, any sort of workers' rights educational assistance done, right? We've got it all ready to go, and it's pretty easy for us to put this stuff together, on a short, particularly doing stuff with Zoom right now. You set it up and we show up and we could do it. In addition, we've got a workers' rights hotline, like I mentioned earlier. Now, if you're a union worker, I'm always going to ask you if you've contacted your union, right? Because I don't, know, and, volunteers that we have, are not going to necessarily know anything about your contracts. Our workers' rights hotline is primarily for non-union workers who need assistance in, fighting discrimination, wage theft, violations of their rights under the National Labor Relations Act, things like that, right? So if any of you have friends, relatives, community members who, have been mistreated on the job or have had their rights violated, I would encourage you to have them call this number, 860-771-8441. We're volunteer staffed. Normally there's, if not myself, someone else, picks the line up. But if not, we always get back to, people we get, within a day. We've handled a lot of wage theft cases and COVID-19 and unemployment things, as of late. If you're interested in finding out more about the Workers Action Project and getting involved in the union and community work we do, again, get in touch with us, come to our website, and, sign up to assist on one of our programs. The way we run is, completely done by rank and file union members and community members volunteering their time and their skills, right? Even if you don't know what you can do, there's something you can do. There's this saying that if you could walk, you could dance. If you could talk, you could sing, right? So every worker has the right to fight for workers' rights. You know what I mean? Everyone's got special skills that we can use, right? And finally, is stand with us and throw some money at the Workers Action Project. We're a 501c3 not-for-profit. And we run entirely on donations from working class people. We're an independent organization, which means our primary funding comes from workers themselves, not from grants, not from political parties, but from workers themselves, donating their time and, their money. So happy to talk. I can stay on for however long we want to do it, for any questions and answers that come up from here on out.
Thank you so much, Mac. That was awesome. You were awesome. That was a really helpful presentation. And a lot of teachers don't always consider themselves to be workers or laborers, but we are, and we're part of a union, and it's important for us to exercise that right of being part of a union. Again, thank you everyone for being here. I want to thank the Connecticut Public School Advocates team and the Connecticut BATS for helping to organize this as well. And in line with being a teacher, I am leaving you with homework. Connecticut Public School Advocates, we're leaving you with homework to do. Number one, contact your local leadership because we are hosting a Union Leadership Summit on October 28th. Number 2, ask your union leadership to hold a meeting. Bring up those 13 safety principles from CEA and AFT at that meeting. Discuss what is being done to protect you in being safe. So contact your local leadership, tell them about the Union Leadership Summit on October 28th. Number 2, hold a meeting. Number 3, wear black on Fridays for solidarity with other educators in hopes that we can be safe. Thank you so much, everyone, for joining us this evening. This webinar was recorded. It will be posted on YouTube. It will be posted on Facebook, and it will also be shared out via email along with all of Mac's information. So thank you again. Please consider donating and have a wonderful evening.